It's actually kind of exciting to see a case we've been covering from the very start go up to the Supreme Court. They heard oral arguments this week in Cox v. Sony, the case that will determine whether entire households, entire businesses, entire regions can be cut off because some corporation claims that one person is pirating. Funny, you'd think that would be a no-brainer. Yet a jury ordered the ISP to pay $1 billion to the music labels for contributory liability to internet piracy. Or, not to put too fine a point on it, they were ordered to pay $1 billion for doing nothing. So this case is going to determine whether or not ISPs should be unpaid enforcers for the RIAA, disconnecting customers solely on their say-so. For an hour and 40 minutes, they heard from Cox, from the federal government, who also thought what happened was silly, and from the record labels. Starting with Cox's attorney, E. Joshua Rosencrantz. No word on who his law partner is, or if his law firm is called Rosencrantz and Guildenstern. Oh, come on, you know I had to.
The consequences of plaintiff's position are cataclysmic. There is no surefire way for an ISP to avoid liability, and the only way it can is to cut off the Internet, not just for the accused infringer, but for anyone else who happens to use the same connection. That could be entire towns, universities, or hospitals. Turning Internet providers into Internet police will wreak havoc with the essential medium through which modern public engages in commerce and speech.
There were 3 standards, the first being the purpose standard. Liability requires proof of affirmative intent to foster piracy, and that does not mean ignoring harassing emails from screeching cartel members. Even if you can believe their claims, that's not enough. There needs to be something else, such as advertising the illegal uses. As Gorsuch explained,
the statute doesn't mention secondary liability, so we should be cautious. And in fact, in Central Bank of Denver, we refused to infer secondary liability in a statute that had no explicit cause of action. But here we are. Sony did it, so okay. The narrowest version of that requires purpose. And we've said that many times, knowledge isn't enough.
And Kavanaugh agreed.
On the word purpose, I think that's going to be key, and it's kind of a slippery word in this context. Mere knowledge alone cannot show purpose.
The second is that the Internet is a passive utility. Just because Internet access enabled them to pirate isn't enough. They couldn't do it without power either. What if they had gone to the power company and told them to switch off the power for the infringers since the kilowatt hours they were given enabled them to pirate? That would be pretty silly, wouldn't it? The Internet has become a vital utility for everyday communication, banking, commerce, speech and expression, even vital activities such as healthcare. Should an entire hospital be cut off just because some of their patients use their Wi-Fi to engage in piracy? That sounds like what the RIAA is wanting to happen. Universities were another example that was brought up, which prompted Alito to say to Paul Clement, attorney for the record labels,
what is an ISP supposed to do with a university account that has, let's say, 70,000 users? What is the university supposed to do in your view?
The university is supposed to, under those circumstances, the ISP is supposed to sort of have a conversation with the university. Now, the ISP's policy to the university says you can't use this service or allow your service to be used for copyright infringement. So that's
all right. The ISP tells the university, look, a lot of your 50,000 students are infringing my copyright. Do something about it. Now, the university then has to try to determine which particular students are engaging in this activity. And let's assume it can even do that. And so then it knocks out 1,000 students. And then another 1,000 students are going to pop up doing the same thing. I just don't see how it's workable at all.
And the third is the Twitter defense. In Twitter v. Tomney, the Supreme Court held that Twitter, now X, cannot be held liable under the Anti-Terrorism Act for aiding and abetting terrorism just because they failed to prevent terrorists from accessing their platform. An ISP, being much more passive than a social media website, should prevail under this standard. Gorsuch pretty much agreed.
Well, a cautionary tale maybe to take account of where patent law is, that Sony relied on in part, for example. I mean, in Central Bank of Denver, as you well know, the court refused to imply any aiding and abetting liability under the Securities Exchange Act. And, so Sony sits in some tension with our law right there.
Well, but that was...
Isn't that a flag on the field for us?
Of course, Sotomayor was as stupid as always.
If I'm a gun dealer and I'm selling to someone who says to me, I'm going to kill my wife with this gun, I think the common law would say, you knew what he was going to do with the gun, you joined in.
And as usual, she doesn't understand even basic concepts of justice.
Meaning, if you know that a particular location and someone in it is committing a crime and you're supplying to that person and perhaps others, it doesn't matter what the others are doing.
Wow! It doesn't matter what the others are doing, just punish them all for the acts of the one.
There are things you could have done to respond to those fringers, and the end result might have been cutting off their connections, but you stopped doing anything for many of them. You didn't try to work with universities and ask them to start to look at an anti-infringement notice to their students. You could have worked with a multifamily dwelling and asked the people in charge of that dwelling to send out a notice or to do something about it. You did nothing. And in fact, Counselor, your client's sort of laissez-faire attitude towards the respondents is probably what got the jury upset.
To your point, Your Honor, that we didn't work with universities, we most certainly did. The first several steps, the 13 steps, are all about contacting them, cutting them off, which we did 67,000 times in the course of this period. That's thousands every month. And third, the program stopped infringement by 98% of the people who were accused of infringement. That is not nothing, Your Honor.
And just in case you were wondering if Jackson would be any better.
Suppose I come to you and I want to buy your services. I tell you that I, as a customer, am addicted to infringing on the internet. I've been sued before. I know what I'm doing is illegal, but I just keep doing it. And not only that, Cox, based on where I live, is my only option. At my new house, it's the only way that I can get internet services. If Cox sells to me, knowing all of that, you still say no liability for secondary liability in that situation.
That's correct, Your Honor. The facts you recited are facts that would make it totally plausible and, in fact, would invite the plaintiffs here to sue that infringer directly. They have recourse in a situation like that. The common law also requires a culpable act, not the equivocal act of selling to everyone on equal terms. Smith & Wesson says that, and Twitter says that too.
Yeah, go after the people committing the act, not basically innocent bystanders. Fortunately, Clement was given a pretty good pounding by Gorsuch.
Even under your standard, that's not what the Fourth Circuit did, right? It didn't say, did you have specific knowledge of individual users who are infringing, and did you do something special with regard to them such that you were substantially certain that you know that they would, in fact, infringe? We'd have to reverse under your standard, too.
I don't think so, but
today. That's not what they held.
Well, I think you and I just read this Fourth Circuit case differently. I read the Fourth Circuit opinion by Judge Rushing to specifically say the substantial certainty test is what's being applied and what makes it.
They applied it in gross, and we've got an amicus brief from some intellectual property scholars that say that was wrong.
The Fourth Circuit says that once you have knowledge that the same customer or address.
Not address, because it could be a lot of people at the address. The customer. And that analysis isn't what the Fourth Circuit did.
I think that is the common law still. I don't think you need.
Of people, I know somebody in this group of people was involved, and I did nothing. That's not substantial certainty. And we have two options. One, we could take the additional step and say that because this is an implied-ish cause of action, we're going to construe it very narrowly. The other alternative would be to say its purpose and reverse and remand. And Mr. Malcolm invited you to say whether you thought you could prevail under that standard below.
Well, obviously I prefer door number 3, but I would also prefer —
I understand door number.
Whatever the standard is, I'd prefer a chance to pursue that. And I would think even under purpose, there has to be room for treating somebody that says F the DMCA differently from somebody that tries their level best to comply and doesn't.
Wow! So a direct attack on freedom of speech! That was the quiet part out loud. The only difference he specified was that the person was or wasn't saying F the DMCA. That is absolute content-based censorship. I would love to have seen a video so I could see the look on Gorsuch's face then. Did he and the other justices pick up on that? You use conduct to infer intent. You cannot use protected expression to impose liability. Fortunately, even the best case scenario for the labels doesn't seem to be giving them what they want. Even the more corporatist judges were arguing for a more moderate viewpoint. At the same time, although I hope the majority finds for common law and freedom of speech, I'm never all that hopeful where the Supreme Court is involved. After all, this is the same court that, earlier this year, said that blatantly unconstitutional content-based identity verification was A-OK. But even going a little bit towards the record labels means contributory liability for infrastructure. So where would it end? The phone company? Cloud hosting? VPN? Discord server admins? Tesla charging stations? It all becomes fair game if this decision goes the wrong way. I'm going to give Rosencrantz the last word.
If plaintiffs want to bring an action that is based upon specific known infringers, they can bring that case under their rule against ISPs. This court cannot affirm on that basis, though, and neither can the courts below. Let's talk about how this case was tried. There is no proof of any specific known infringer that is a human being who actually did any of the things that some of these hypotheticals spun out. Even if you focus on households, there is no way to disaggregate precisely for the reason that Justice Gorsuch points out. Plaintiffs tried a case in gross as to 57,000 subscribers, no individual circumstances. Plaintiffs never tried to disaggregate in any way as to the people who they claim can sustain this verdict. You can't infer liability from the blank page, and Congress said not to do that. The DMCA is also no panacea. ISPs have no certainty that they will keep the safe harbor. A lay jury decides whether an ISP has acted reasonably and whether terminations are appropriate. Justice Alito asked, what is an ISP supposed to do when confronted with a university? My friend gave an answer, have a conversation. That's a terrible answer from the perspective of the company that is trying to figure out what its legal obligations are facing crushing liabilities. I have an answer. How about a conversation with the ISPs where they talk about how to work out things together? Maybe they kick in a little money. Now, they won't get billion-dollar verdicts, but if they believe that the programs that Cox and others have aren't satisfactory, they can design better programs and help pay for them.